Good morning, please be seated. We are here today in the matter of Sunland Dairy versus Milky Way Dairy, our case number 1CACV 20-0057. We're here today for oral argument. Each side is allocated 20 minutes. Appellant, you're free to reserve some time for rebuttal if you'd like, but you got to keep track of that yourself. I believe you can see the calendar, the clocks in front of you. I think we've reversed them, so the clock that says Peli or whatever is actually for you over here on this side and vice versa. We have conference this case this morning. We reviewed the record and the briefs, so we're pretty familiar with the arguments, and just keep that in mind when you are choosing how to allocate your time during oral argument. We will be live streaming this for the literally one or two people that may be watching somewhere, and we will also post later the oral argument to YouTube, so you can go back and review your work. But so that people who may decide to watch can keep track. Please, when you announce, tell us who you are and who you represent. I feel like I've left something out. No? Good. All right, with that, we will begin. Thank you. And your council table. And over there, since you're two of you, I'll leave it to you on whether you want to leave your mask on or take it off while you argue.
Thank you, Your Honor.
Thank you.
Good morning, may it please the court. My name is Alex Winkleman and I represent appellants Milky Way Dairy and Ari and Nina DeYoung. Milky Way asks this court to vacate the judgment in favor of Sunland on the basis of any one of four legal errors. In considering these errors, there are four facts this court should keep in mind. One, Milky Way performed nearly $1 million in feed services for Sunland. Two, Arizona law granted Milky Way Dairy a feed lien over those animals. Three, Sunland never paid Milky Way. And then finally, four, Milky Way removed identifying ear tags from Sunland's animals without complying with the feed lien statute. In light of these facts, the judgment below violates Arizona law in four ways. One, the trial court imposed a treble damages penalty from a criminal statute without an express or implied private right of action. Two, the court's jury instruction on conversions.
Is Title III exclusively criminal title?
No, Title III deals with the regulation of agriculture in Arizona. Third, the trial court improperly calculated the amount of the treble damages penalty by ignoring Milky Way's feed lien. And four, the trial court awarded attorney fees for claims arising from tort. Now, I'd like to get into the private right of action first. I think it's very clear there is no express right of action here.
Why do you say very clear?
Because when the legislature clearly creates a private right of action, they reference an action and the right to bring one. And a good example of this is ARS 3-1295, the feed lien statute, which specifically identifies that a party may bring an action and even specifies that that action must be brought in superior court. So the legislature knows how to create an express right of action, and I think this is not a case like that. At best, this is an implied right of action case.
I don't see what's implied about saying shall be liable to the owner. Why does more magic words needed to create an express right of action?
Because liability and the right to sue to impose that liability are distinct concepts. The legislature.
What's your authority for that?
Excuse me?
What's your authority for that proposition?
Besides the plain meaning of those words, you can look at
you said the impositional liability and the right to sue to collect that liability are separate concepts. I'm wondering, what is your authority for that proposition?
There are numerous statutes where the legislature has created liability, civil liability.
So your authority is, there's other examples where they've chosen to do more.
Correct, Your Honor. Well, and I also think.
So what are they doing if they say there's liability to the owner? Are they just saying, oh, a pat on the head? Oh, you had liability. I mean, they're giving you something. They're giving the owner something. There's liability to the owner.
So Arizona specifically rejects the Supreme Court's private right of action jurisprudence, which centers on whether or not the legislature creates a right. There are numerous examples in case law, such as Gersten and in Napier, where a statute creates a right but does not necessarily create a right of action.
Yeah, but it doesn't create liability. Those examples don't say you have to pay this person.
So in the animal cruelty statute, which I don't recall the exact number off the top of my head, but it's in the appendix that I prepared in my reply brief, the legislature specifically indicates that those fines shall be paid to the victim. Criminal restitution is a right created where monies are paid directly
But
to a
in criminal
victim.
restitution, can you triple the damages?
Sorry,
Under a criminal restitution context, can you lawfully triple the damages?
I'm not aware of any case law or statutes which would permit the state to treble a restitution award.
So then what is the meaning of the 31304 when it says liable to the owner of the animal for 3 times the value thereof?
I think it's very clear from the title of the statute and the legislative history that it was an attempt to impose an additional civil penalty. And if we look at the initial precursor statute to 3-1304, that
An
statute,
additional civil penalty. What does that mean?
an attempt to punish
It's a
through the
civil-
application of
it's
a fine.
then?
Correct.
Or a civil fine?
I believe it is absolutely a civil fine.
Can you give me another example where the legislature the legislature has created a civil fine using language of liable to the owner?
And the civil fine is to be paid to the owner, not
Yeah.
just a civil fine where it goes to the government. We're talking about a civil fine that is actually going to be paid to the victim of the civil action, to be brought by the governmental agency.
So, I believe, I've covered this in my brief, but I think ARS 3-935 uses the phrase is liable and has that paid.
ARS 3-935, you said?
934, my apologies. And there are numerous examples in the criminal codes and in civil codes where fines are imposed.
And they're all payable to the state.
They're all payable to the state. But under the implied right of action analysis here, whether or not it's paid.
I'm still hung up on express.
So I don't think that the phrase liability is clear in that case. I think we do have to look at the context of the statutes.
It's not just the phrase liability, it's liability to the owner. And I'll just give you a pointer from me, is like when you say clear from or statutes provide, point me to specifics or I just usually tune you out.
Sure. So the phrase liability means responsible. So here, what the legislature intended to do was impose responsibility to the owner upon the finding of certain criminal acts. I think if you walk through the plain language of 3-1304, the conjunctive and tells us that when a person overbrands an animal, that person is guilty of a class 4 felony and is liable to the owner of the animal for 3 times the value thereof.
Okay, what is that and defining? Other than an express right of action, this person can collect it. Otherwise, it doesn't mean anything.
It's a civil penalty, Your Honor.
A civil penalty, what does that mean?
It is a fine
Okay.
in order to punish
So this
criminal
is
behavior.
the only example in the legislature, except for maybe 3-934, where they've said a fine that the state can assess is a civil fine and it's payable to the victim.
One moment, Your Honor. So in Sunland's answering brief, they prepared an appendix of statutes. And in our reply brief, Milky Way responded to each one of these statutes. In the dog bite context, there are situations where money is paid directly to the owner. In the railroad context, there are situations where money is paid directly to the owner. In an animal cruelty context.
Do these say, and I should know this, but I will admit maybe I don't. Do these say liable to the owner Or do these say the state shall assess a fine and then that fine shall then be paid to the owner?
Unfortunately, Your Honor, I'm not sure that the statutory language is consistent throughout these.
And I was looking at some of those, and it seemed to me that some of those were just restitution. That you could pay part of a restitution to the owner, or not the owner, but the victim of the civil action. And as Judge Cruz pointed out, in a criminal context, restitution is limited by actual damage. So why, if that's the case, then isn't that different here? Because I mean, here it's clear it can be treble damage.
So, if I understand the court's question, I think what the court is getting at is that where the legislature has created a right that is payable only to one party, the court would interpret that as an express grant of a right for that party to sue to obtain that remedy. Am I understanding the court's question correctly? I think that's been expressly rejected as the proper legal test in Transamerica. In the federal context, the creation of a right which inures to the benefit of only one party is dispositive. But Arizona has expressly rejected that analysis in Transamerica and instead asks this court to focus on a four-factor test. And because my time is running short and I'd like to reserve some time for rebuttal, I'd like to hone in on exactly what the issue is here. Sunland has a way to access this treble damages penalty without a private right of action. In Gersten, we saw that this court rejected finding a private right of action where there was an ability to issue a complaint to a disciplinary body. Here, Sunland had the right to seek redress from the criminal system and did not do so, or at least did not do so in a way that made it into the appellate record.
So their ability to recover this shall be liable depends on whether or not a local county attorney is willing to take on a prosecution.
Correct. And the reason for this is that Sunland had...
That's not much of a right.
I think it is, because Sunland had duplicative rights. They had a right to bring a conversion action.
No, I mean...
They had a right to seek punitive damages.
There's tons of case law that talks about, in the criminal context, how the governmental agency is not bound in any way by the victim of criminal behavior in bringing a criminal charge. It's totally discretionary.
Correct. But this is for criminal behavior. So that discretion should lie with the state, because this is a penalty designed to punish for criminal behavior. This is not a statute designed to balance the scales and remedy some wrong. This is a statute designed to punish for what is unquestionably criminal behavior, as defined by the legislature. The legislature has routinely affirmed that this is a criminal statute, and these arise to protect cattle feeders from cattle rustling. These are not statutes designed to help regulate the cattle feeder, cattle owner relationship. And because of that, the application of it here led to a situation where we were applying treble damages for failure to strictly comply with a feed lien statute. And without more express language in the statute, I think it's a mistake to read more into the legislative intent there based solely on is liable to the owner.
But isn't that what we're doing when we're reading that it is a civil fine? That's not part of the statute.
Sorry.
You propose that the portion of the statute that says that is liable to the owner of the animal for 3 times the value thereof, that we're talking there about a civil penalty or a civil fine, right?
Imposed for criminal conduct.
But that's not language that's included in the statute. I mean, we'd be reading that in, that it's imposed as a civil penalty.
I don't think that that's necessarily being read in. If you look at 3-1307C, it says, in addition to any other penalty imposed by this section, so...
In addition meaning in addition.
Not
So
instead
have a
of...
list of penalties, and you are also liable to the owner.
Right, but that implies that one of the other penalties has been assessed.
No, why does it imply that?
It doesn't say in lieu of any other penalties. Or,
Right, it doesn't say it's either or, it's saying and. So you can get this and you can get that. Isn't that the plainest reading of the plain language of that statute?
If you read further, it says a person depriving the owner of the use of his animal or animals under subsection A or B of this section.
In addition to any other penalty.
But that requires a
listing the
finding
penalties.
that the person committed a class 4 felony, because subsection A or B are both felony offenses. So here, a person depriving the owner of the use of his animal under,
It doesn't, no, the legislature didn't say, if someone is found guilty of section A or B, then they shall also be liable. That's what you're wanting us to read this as, right?
I think under the plain language,
You want to read the plain language as, in addition to, meaning if you're guilty of.
if there is another penalty, in addition to that penalty, you get
Where's
this other
the
penalty.
if there is another penalty language?
I mean, there's also no language indicating that there's a private right of action here. So I think we're already in the zone where we're having to imply the legislature's intent, because they clearly
You
don't
mentioned you
say.
had 4, and I think if you're going to have any time for rebuttal, you should probably get to some of your other issues as
Before we
well.
go down that route, there was another portion that I wanted to cover. You referenced 3934, correct?
Yes.
ARS 3934, but there, it says that a person who violates an order pursuant to this section, in addition to any other penalty or remedy for contempt of court, shall forfeit and pay to this state a civil penalty. And so, differing from the language that we're reviewing in 31304 that talks about liability to the owner, not liability to the state.
So I can scratch that off as the example,
Sure.
the counterexample? Okay.
So let me move on, since I'd like to make sure I reserve some time for rebuttal. As to the conversion instruction that was imposed in this case, the trial court imposed a wholly new measure of damages in this case. In Arizona, the damages for a tort are fixed at the time and place of the tort. Here, the court imposed a measurement of damages which was originally used to prevent securities fraud, or
What is your authority for there's one measure and it has to be measured at the time of conversion? I assume you're referring to Jones v. Stanley?
Jones v. Stanley, Professor Dobbs has listed cases in Arizona which deal with that. The comment to Section 222A of the Restatement of Torts references that issue, and if you'll give me one moment. I also cited a number of other authorities in my brief on this issue.
But the restatement clearly recognizes the highest intermediate damages or highest intermediate value theory of damages.
Correct, but only in limited circumstances. And there's never been a case that I've been able to find which has applied it in a cattle context.
You familiar with Wolk v. Nichols?
Can you tell me what authority that?
117 Arizona 352 from 1977. It
I'm
was a
not.
conversion action involving trees, and there the Arizona Supreme Court, which decided long after Jones v. Stanley, said you could actually measure this at the time of you could figure out damages at the time these trees would have matured, which is some future date long after the conversion occurred. So why is Jones v. Stanley binding on us, but Wolk v. Nichols isn't?
So fundamentally, these animals could have never been sold for the price that the jury awarded. These animals had a limited.
As a matter of law, they could not have.
No, as a matter of fact.
Why?
Because these animals have a limited lifespan. Their economic lifespan is limited. The conversion, if you look at Trial Exhibit 54, were found to have occurred at a rolling period over 2013. These animals calved and became milk cows rather than Springer heifers throughout the summer of 2013.
Isn't this a fact question that the jury could be presented with as to when?
But the jury wasn't permitted to make any factual determinations. The jury was instructed that it had to use the highest value between when the conversion occurred and a later date. They were not given discretion, like the standard in North Carolina
The
is.
highest value, but that presumes that the jury determined this is a value that these cows could have sold for during that period of time.
I'm not sure that was actually how the jury was instructed. What they were told was that Milky Way converted the animals.
Right,
And
and damages is based upon the highest value between the date of the conversion and the date in which Milky Way discovered.
Correct, but it was not for these animals. It was the highest value for replacement animals. And fundamentally, this was not a commodities case. Sunland routinely argued that their animals were special. This was not a matter of you promised to return 523 cows. They indicated that they needed their 523 cows back. So these distinct animals could not have achieved that price on the market when it was sold. Since I'm running out of time, I'd like to reserve the
Was there expert testimony about what the value of the cows was at the time of when Sunland discovered the conversion?
No, their expert put on testimony about what the value of replacement animals was.
Okay. And you're saying that's wrong because?
That's wrong because this was not about replacement animals. This was about Sunland's specific animals. And at the end of the day, Sunland's specific animals could have never been sold for the value that the jury assessed.
Is that? Okay. You want to save your time?
I'd like to reserve the rest of my time.
Okay. Thank you very much. Counsel for Appellee?
Thank you, Your Honor. Chris Banaszewski on behalf of Sunland Dairy. I'd like to take up the issue that you were just talking about first, and that's the highest intermediate value matter. I don't think that there's an Arizona case that has directly decided this particular issue. The McFadden court did award a highest intermediate value, but that was a breach of contract case dealing with the sale of beef cattle. So the court did apply that, but as to the specific issue of for a conversion action for property that fluctuates in value and can be purchased on an open market, I don't think that precise issue has been decided in Arizona. But most of the jurisdictions that have looked at this issue have determined that some form of the highest intermediate value rule is appropriate. And we cited you a number of cases. We cited you going all the way back to the Supreme Court case in United States Supreme Court case in Gallagher, and a couple of other secondary resources that all conclude that when this precise point has been considered, some form of the highest intermediate value rule has been adopted. But the only thing I wanted to say on this issue was that if for any reason the court thought that that rule was unreasonably expanding the damages for a conversion case, I would suggest maybe that the court do what the Supreme Court of the state of Washington did in that Glaspie case. That was the case where apples had been delivered to a packing and storage facility, and the defendant sold those apples without first foreclosing on they called it a mortgage in that case. So just like Milky Way did not foreclose its feed lien before selling Sunland's animals. And the court made a distinction between ordinary conversion and willful conversion. And they said in a willful, and looking at those two scenarios, they said certainly in a willful conversion case, it's appropriate that an intermediate value rule be applied. And they went on to note that, a willful conversion is when one has possession of property of another for a specific purpose, and contrary to that purpose makes an unauthorized sale. Exactly what happened in this case. And in addition, to show the willfulness in this case, the jury to find in favor of Sunland on 3-1304 had to specifically find that Milky Way intended to convert the animals. And so that finding was made. So even if this court were to limit the applicability of the highest intermediate value rule to a willful conversion, the judge's instruction in this case was appropriate.
What his argument, at least as I was hearing it towards the end, there was a little different though. Is even if we accept the highest intermediate value, that this was still a wrong calculation as applied to this case, because you guys argued that there was something special or unique that would not allow them to be treated as the going price of cattle on the market.
If anything, the testimony at trial was that our Sunland animals would have had a higher market value than just your normal dairy cow. I can go into the reasons for that.
Your expert just testified about the normal market for dairy cows.
Yes, and that's what because we couldn't get our animals back, we said, okay, well, we're entitled to the value that you would be able to receive, in the market. And that's what our expert testified to, were the market values that certain dairies had actually received when they sold animals on the open market. One of the other issues that they raised on appeal that we haven't gotten into yet is that the issue of whether, because of the treble damages issue and the offset that Sunland always agreed that they were entitled to an offset for the feed costs. And the question is, well, when you treble the damages, do you take the offset first and then treble the damages, or do you treble first and then take the offset?
And let's assume, just for sake of argument, that I agree with you that treble damages means you calculate the value of the heifer and multiply it by 3, and that's your damages. Does it change things that there's a feed lien in here? In other words, that I understand his argument that, well, the value of that cow was reduced because there was a lien attached to it at the time of the conversion.
Yeah, no, I wouldn't agree, because that changes the term in the statute, I believe, from value to equity, to the equity that the owner had in the animal. And that's just not what the statute says. It says value, just like your house. So you have a mortgage on it. You don't say the value of my home is whatever it is less
or
the mortgage.
If we were dealing with a restitution issue without the setting of treble damages, is the restitution for the sale of the car the value of the car or the equity you own in the car?
Correct.
Now, it may be that there's a claim he also owes to the bank for part of it, and there might be an offset or something, but that's still, he has to pay the full value of the car if he stole your car.
Correct.
Okay.
We would then have to pay for the feed, but that doesn't affect the value, what the animal would have received on the open market. And I think that's the test, and that's really any definition of value that you look at takes into consideration what the owner would receive, in a fair exchange on the open market. And so I think that's what the statute says, and that's what should be followed. And the other main point I wanted to make there is and what I think is interesting, if you think about it, is what the court in the New Jersey case, that Truesdale versus Carr, they said, look, it was a very similar case. That had to do with a wrongful eviction case, and they brought damages for wrongful eviction. And the landlord said, hey, you owe me for rent. And the landlord tried to make the same argument. Well, hey, you've got to offset what you owe me for rent before you treble your wrongful eviction damages. And the court said no. And the court said, if you look at the actual economic effect of doing that, is that you end up trebling the offset.
Treble the rent.
And so you would have trebled, doing that, you would treble the amount that that Sunland owed for the feed. And the court said, that's just inconsistent with common sense and the purpose of the statute. And I think that same reasoning applies here.
One of the things in the restatement going back to the damages issue, it talks about a market. I can't remember the exact language in the commentary of the restatement, but things that are readily tradable. Is there evidence in the record below to support the notion that these cattle were readily tradable on I'm forgetting the exact language, but that they would match what the restatement requires?
Yes, and in fact, our expert testified to that. There is a regular market for dairy cows. It's at least once a month, if not more frequent than that. And the way he came up with the values of the cows we had him do the value of the cows each month for the period of almost a year, I think it was the evidence that we presented during the relevant time period. And he testified that those values came from the regular sales that occurred on the open market. So yes, there is testimony in the record as to that. I would like to get to, if I can, the couple of issues that we have on our cross appeal, if I can, unless there's any questions.
Your time, so use it how you think best.
Okay, thank you. So our first issue on the cross appeal has to do with prejudgment interest. We asked for prejudgment interest on the judgment below, and the court determined that our claim was not liquidated. And as I know, I'm sure you know that prejudgment interest is a matter of right when the claim is liquidated. And what the
What's your
cases say.
best case for finding a situation like this where we have the value dependent upon expert testimony as to the price of things traded on an exchange and subject to an offset for things that are to be determined by the court, that equals a liquidated damages claim? What's your best case that says this is on all fours here and we should apply liquidated damages to that?
Yeah, we cited a whole number of cases. We had a.
I know, give me your best one.
Um,
I'm lazy, I want to just read one case.
I can't remember the best one off the top of my head here.
Sorry, didn't mean to put you on the spot.
No, that's okay.
I guess what we're
I'll have her get
interested
to the
to
page and then
know,
I'll pick one.
I guess what we're interested to know is the fact that the jury was asked to determine the highest intermediate value, doesn't that weigh against finding that damages were liquidated?
No, and here's why I say that. And I think the trial judge has had the same concern that you do, that, well, there was expert testimony and it was the market values. But the market value was specific data that the expert provided. It wasn't necessarily his opinion of the market values. He took actual data from actual sales on the open market and took those and came up with a monthly amount for the milk cows. And so he looked at objective criteria, actual sales on the open market.
And then gave an opinion.
His opinion was but limited to what the actual data showed. He just testified to the facts of the actual data. Now, he did average them for the month, but he had 7 different dairies and there were different markets, and so he did have to do that, but that's still a specific calculation based on actual objective data. It wasn't like something subjective like humiliation, pain and suffering, loss of consortium, things that are very subjective to the person. He testified to actual facts.
I think she's trying to give us that case.
Oh, okay. Thank you. No, where are the market value?
While you're looking for that, maybe I can ask
Yeah.
a follow-up question. It just seems to me that what we're talking about here, well, he may have said, yeah, this is the actual sale. This, and somebody else could have done some other sales, and you could have kept going and going and going, and ultimately it's the jury who's going to make the determination based on looking at all of the sales and making a conclusion about what was the appropriate amount.
Mm-hmm.
So why is that?
Well, I take that from the Alta Vista case that says that all that is necessary is that the evidence furnished data, which, if believed, makes it possible to compute the amount with exactness.
Without reliance on opinion or discretion.
Correct.
Okay. And then the point I wanted to add in too was there's the offset as well. So those damages are reduced by the offset, which is not a calculation that was pointed to by discrete, specific values on an exchange.
It was not, but the jury did find an exact amount per cow of what the offset was based on the testimony presented by Milky Way as to what they incurred to feed, vaccinate, and breed.
And
so that number itself was a
fixed. You didn't contest that
fixed.
data at all?
I'm sorry?
You didn't contest that data at all? You stipulated to the amount?
No. There was a dispute. We said it was a lower amount.
And the jury ultimately, based upon its discretion, came up with that was the correct amount.
No, it chose their facts over our facts, I think is the way to look at it. Because, the other cases say, just because there's a dispute as to the facts or a dispute as to the amount, doesn't make the claim unliquidated. It just means that the jury has to make a factual determination, but they are still making an exact calculation of what those damages are. So, our other issue on appeals, going to that, is the attorney's fees issue. and what is the standard that should be used to evaluate the reasonableness of a contingency fee. The case, the matter of conservatorship of Fallers and Geller, my reading is that it's pretty clear that the reasonableness of contingency fees is based upon the factor set forth.
That's a reasonableness, though. The cases you cite are reasonableness in the context of ethics, whether it's ethical for an attorney to enter into those fees. It's not a China doll or a case saying those are reasonable fees that can be awarded, which are very different concepts.
I agree, but I think the matter of conservatorship of Fallers specifically says that in reviewing the reasonableness of an attorney's fees request based on contingency, you look to Schwartz, not China doll. And I think the Geller case says that too when it's talking about the contingency fee. So unless I've misread that case.
What about Cruz v. Collins, which is a 1984 case out of here, where we say, defendant's obligation to pay reasonable attorney's fees. The fee arrangement with plaintiff's counsel does not per se imagine that the contingency fee was reasonable. Evidence of reasonableness of the fee is necessary. And I think subsequent cases here we've held too that this kind of sets a cap, that the attorney's fee agreement or the contingency fee agreement sets a cap, but it doesn't establish the actual amount. The amount still has to be reasonable based upon the China doll.
I guess that's where I would disagree based on my reading of the conservatorship of Fallers, where I think this court said, and again, unless I'm just reading it wrong, it says that in assessing the reasonableness of an attorney's fees award based on a contingency amount, you look to the factors set forth in Schwartz, not China doll. And one of the main reasons for that is what the trial judge did in this case. She was obviously uncomfortable with the effective hourly rate that would be awarded if she awarded the fees based on the contingency amount. But in Schwartz, which is what Fallers relied on, it specifically said that, the effective hourly rate is not a consideration because that doesn't recognize the risk in the case. The risk of winning, the risk of the time and effort that you put into the case without getting paid. And Schwartz says, so the contingency fee may be much larger than the attorney or others in the community would have charged had they been retained and paid on an hourly basis. And so, in my view, I don't believe, because the trial court clearly relied on China doll. She cited it in her judgment. And I think that was wrong. I think you're supposed to look at the factors set forth in Schwartz rather than the factors set forth in China doll. Unless I'm just completely misreading
I'll
that
certainly
case.
go back and reread those cases and see what they say.
Okay.
As a follow-up on that point, I mean, just theoretically, we're talking about, when we're talking about the awarding of fees, we're talking about something, it seems to me different than, you're talking about the risk that you are putting up, but why should we transfer that risk to the other party when we're talking about basically, I'm struggling with this, I don't.
Sure. And I think the reason for that is it ultimately goes back to, okay, so we took on a lot of this risk, and as a result of that, we were charging that to the client. And so the client then, their ultimate recovery is lessened by the fee agreement that the client has with us. And therefore, it's the purpose of the award of attorney's fees is to offset the amount that the client ends up having to pay the attorney.
Right,
so I think...
Isn't that kind of conflating the personal injury versus contract? I mean, in contract law, if you had agreed, and we're setting aside the contingency fee, they're going to pay you $2,500 per hour. If the trial judge looked at that and said, that's just too high, I'm not going to make them pay, they would still be on the hook for $2,500 an hour, but the court would have been completely within its discretion to say, and isn't that what she did here? She said this fee that would result as a result of that is the same as if you had agreed to $2,500 per hour, and I'm just not going to find that's a reasonable fee.
So you're asking us to order her to impose an unreasonable fee.
Well, I guess what I would,
She found, she said it would be unreasonable.
she found that the 50% would be unreasonable, but her ruling is, in effect, is a less than 22% contingency fee. And I mean, to me, for this type of case, given the issues, all of the hotly contested,
You don't believe you're adequately compensated for your work involvement?
I don't think that
But you're still getting paid because you have the contingency fee.
if we ultimately
But I'm saying,
win
going
and-
back, if it wasn't a contingency fee and you had agreed with them to pay, they would pay you
Mm-hmm.
$2,500 an hour, and the trial judge said, no, I'm going to award you $500 an hour,
Correct.
it would come out of their pocket, which is what you said we shouldn't be doing.
No, I guess all I'm saying is that I don't think the trial
And I
judge.
assume those are your clients behind you. I'm pointing at the
They
table
are.
and
They are. Thank you.
I'm sorry.
Yeah. That in looking, again, just looking at the reasonableness of the fee, you have to look at the basis upon which the fee was incurred. This fee was not incurred on an hourly rate. It was incurred on a contingency arrangement. And I think, and that's why you look to the Schwartz factors to determine reasonableness rather than China doll. And so
We're out of
and
time, so I'm going to cut you off.
Sure. Thank
And
you.
you went about 1 minute roughly over, so we're going to add 1 minute onto appellant's side unless you have some objection.
No, Your Honor. Thank you.
Appellant?
Thank you. So with regard to the liquidated damages, I'd like to direct the court's attention to Pueblo Santa Fe Homeowners Association, which indicates that the reason why no interest is allowed upon an unliquidated sum is because the person liable doesn't know the sum he owes and therefore can be in no default for not paying. Here, the amount that Sunland claimed that Milky Way owed changed over the course of this litigation, and there was never a point when Sunland made demand to be paid the amount that the jury ultimately awarded. And I think that's very clear evidence that this is not a liquidated sum. As to the conversion damages, I would like to direct the court's attention to the Spindler case out of Texas, which was cited in the briefs. And in that case, they discussed 3 truckloads of goods: tomatoes, eggs, and stone, all going to be used or sold at a different point. Here, these animals and the testimony below as to the values that the jury ultimately adopted were for replacement Springer heifers. In July 2014, when the price of replacement Springer heifers hit a 30-year high, none of Sunland's animals were Springer heifers. All of Sunland's animals were milk cows. And for that reason, it was improper for the jury to award an amount of damages that these animals could have never, ever
And
received.
did your
at market.
expert testify about that?
We didn't have an expert. Their expert will testify.
Could you have put on an expert to testify as to these facts?
We could have, but their expert testified to these facts. Their expert testified that a Springer heifer is when an animal is at its highest value because it's actually 2 cows and you get the entirety of its milking life.
But your objection to the highest intermediate value was not based upon this below. I'm wondering where this argument's coming from.
Judge, our argument related to this below was that using...
Your argument below was it should be measured at the time of the conversion.
Correct.
And that was your objection to the highest intermediate value.
And that it coheres with Arizona law, which the purpose of...
Here's the one case, not the other case that I cited earlier.
Sure. But the purpose of tort damages is to put the party back in the situation that they would have been in but for the tort.
Right. And is it... The question I'm seeing is it reasonable to say it's locked in when only you knew of the conversion, or is it locked in when they knew of the conversion? Which seems to be both of those kind of are reasonable approaches you could take. I'm wondering why yours is the correct one.
Well, even if mine isn't the correct one, the one that the judge used, which took the discretion away from the jury to balance the equities in determining when to fix that, was incorrect. Because here, the jury wasn't asked to find what would be a just value to apply between the time of the conversion and the time when they learned of it, or as they formulate it in North Carolina, between the date of trial and the time of the conversion. The jury's given discretion to determine what would be an appropriate value for those animals, and that discretion was taken away from the jury here. And the jury was forced to find that the highest value was the value of the animals. They were told that the market value was the highest value that occurred
And
between.
you could have put on evidence to contest what you thought was an appropriate value for their animals, and you didn't.
So I don't think that's accurate, Your Honor. I think that what we put on evidence was that these animals had a value at the time they were converted. And I don't think there's any dispute about what happened to the price of animals. I don't think that there's any dispute that it fluctuated. And I don't think there's any dispute that it hit a 30-year high. But what I think is in dispute is these particular animals were never worth that amount of money.
Okay. We're out of time.
Thank you, Your Honor.
Thank you both very much for your arguments today. Thank you for accommodating our schedule shift as well to let us move this up from Wednesday, so we're grateful for that. We will take this matter under advisement and issue a written decision in due course.
Thank you.